Good afternoon. Hopefully we're all in better condition than just before lunch. I'd like to thank the summit organizers for the very interesting and educational value that all of us get from this conference. It's nice to see a very large group of young people who are breaking into the IP field. And just from listening this morning, I know that you will be getting a very wide variety of topics on intellectual property. This morning, Mr. Dougal, if I'm pronouncing that correctly, he made a very interesting presentation. This year I will be in the IP field for a little bit in excess of 40 years. And even with all those years under my belt, I found his presentation to be very interesting. I'm not sure if it was because of his topic of human relations and sexuality and all those interesting topics, but that's at one extreme of the IP field when it comes to enforcement. My presentation will be a far more pragmatic, dealing with basically details of prosecution before the United States Patent and Trademark Office, which is where my firm's and my own personal specialty is. I also found Mr. Mehta's presentation very interesting. There will be, as you will see, there will be a little bit of an overlap between his presentation and mine. Perhaps the best way I can characterize it is Mr. Mehta's presentation with regard to reexaminations, which is what I'll be discussing, dealt with the future. The American Invents Act has introduced a lot of changes into how things have been done in the past. I will focus a little bit more about the present also, how things are currently handled. And the reason for it's important to know that is even though the law introduces a lot of different ways to review the continued patentability of claims in a patent that has issued, everything revolves around filing dates. So the applications that were filed prior to enactment of the new law on September 16, 2011, all those will still be handled under the old law. And so it's going to be very difficult and very challenging for the younger generation because you're going to have a very large pool of cases to be concerned with how they are handled under the old rules, while at the same time, beginning on September 16, 2012, and some of the provisions kick in on March 16, 2013, all those are going to fall within a brand new set of rules, and yet those of us who have studied these changes a little bit have already come up with some ways of prolonging the time under which the old rules will apply, if that is helpful to our clients. So moving to the details of my presentation, reexamination practice is what I'll be discussing in details. Just so you have a clear understanding, under U.S. patent law that's currently in effect, there are only three ways to have the patent office get involved with an issued patent. Issued patents in the U.S. are presumed to be valid. Once they're issued, the agency is out of the picture, except for three specific situations. For minor changes, minor corrections, certificates of corrections are handled by the agency. One can reissue an issued patent, or one can request reexamination. Those are the only three ways of looking again at an issued patent. My focus will be on reexamination. What causes the typical reexamination request to be filed? Typically, a patent owner will find that there's an infringer out there, or so they think, and they may send a threatening letter, or perhaps not that threatening, just inviting the accused infringer to take out a license to the patented invention, or they may actually sue an accused infringer. In both situations, the typical reaction on the part of the accused infringer is to say, I am not infringing. Furthermore, your patent's not valid, and I'm going to show you that it's not valid by requesting reexamination. So this is the so-called third-party reexamination request. On occasion, in a similar situation, the accused infringer may tell the patent owner, your patent's not valid. Here are a couple of patents that were not considered by the patent office. They make your claims unpatentable. One of the things that patent owners can do then is they themselves can go to the agency, request reexamination of their own patent, bring these new references to the attention of the patent office, request reexamination in the hope that the claims will still be confirmed, and now they're in a far better position to perhaps take that accused infringer to court because they took away the other side's ammunition. There are basically two types of reexaminations. One, the so-called ex parte, and those of you who are not familiar with the Latin term, basically what that means is that everything is conducted strictly between the patent owner and the examiner at the patent office. So even if the third-party requester files the reexamination request telling the examiner why the claim should be rejected, once that filing is done, to a large extent, the third-party requester is out of the picture. Now it's all between the patent owner and the patent office. The other type of conducting reexamination requests currently are the so-called inter-parties, where the requester, obviously a third-party requester in this case, participates throughout the proceeding. They get to do everything pretty much that the patent owner gets to do. Because of the changes in law under the American Invents Act, different criteria will apply depending on filing dates. There's been no change with regard to ex parte proceedings in this regard. With regard to inter partes proceedings, only applications or requests filed prior to September 16, 2011 fall into the old rule. There's a different rule that will apply that I'll discuss in a few minutes for anything that was filed after September 16, 2011, but prior to September 16, 2012. And then after September 16, 2012, inter partes reexamination will no longer be permitted. I mentioned who can file the reexamination requests. In the inter partes reexaminations, the true party in interest, the requester, must be identified. In ex parte proceedings, one need not identify the true requester. Why would somebody want to hide their identity? And as I said, it can only be hidden in an ex parte proceeding. The reason is if you identify yourself as a requester and you are a company manufacturing a certain product, it's very likely that the patent owner will suspect that you have an interest here in requesting the reexamination. You're probably infringing or coming close to it. They're going to investigate your products. On the other hand, if you could somehow find a way to do this anonymously, the patent owner will not be in a position to investigate your products. I will now discuss ex parte proceedings, which, as I said, have not been changed. One must show a substantial new question of patentability in order to have reexamination request granted. Typically, that's based on a new reference. If there's a new reference, it's very likely that you can raise a substantial new question of patentability. Sometimes even a previously considered reference can form the basis of a substantial new question if you can put a new light on that reference. One quick example, perhaps a foreign language document is what was discussed in the original examination. You now provide a translation to the examiner of that foreign document, and a position taken by the patent owner during prosecution, or perhaps the examiner in indicating why a claim is allowable, is in fact contradicted by the translation of that reference. So you can put that reference in a new light and persuade the examiner that in fact a substantial new question of patentability exists. So this is kind of the easy part. The more difficult part is you also have the obligation of showing the examiner that this new reference is not only does it raise a substantial new question, but it's also non-cumulative in nature, meaning generally speaking the disclosures will be different. They'll almost never be identical unless it's a continuing application of an earlier issued patent. But that's not enough. Insofar as the claim subject matter is concerned, you also have to show that the disclosures are sufficiently different from each other that this new reference is non-cumulative of an earlier patent that had been considered by the examiner. Where we are today with inter-partes re-exams, meaning anything that was filed after September 16, 2011 and prior to September 16, 2012, instead of a substantial new question of patentability, you now have to show that there's a reasonable likelihood that the requester will prevail with respect to at least one claim. You don't have to show it with respect to all claims. Also, examination will now be done by the Patent Trial and Appeal Board judges rather than a group of examiners. After September 16, 2012, as Mr. Mehta discussed earlier today, the inter-partes re-examination request will be replaced by a petition to conduct inter-partes review. We now have some new ways to challenge. As was mentioned earlier, there is the post-grant review, supplemental examination, and there's some transitional provisions that have been introduced strictly for business method patents. Personally, I have some doubt about how well the agency will be able to carry out its congressionally mandated directives with all these different ways of challenging the validity of the patents. Those of us who practice in the United States, we are aware how lengthy and drawn out the procedures are with regard to ex parte and inter partes re-examinations. And that's primarily because the PTO staff is overloaded. They have too many of these cases that they're very complex. Imagine what will happen now that we have at least two other ways of challenging the validity of the patents. I think I'm a little bit concerned with the agency's ability to carry out its congressionally mandated responsibilities. I just don't see how they will be able to train so many new people in an entirely new way of challenging the validity of patents. If re-examination is requested by statute, the agency must make a decision within 3 months. The decisions that the examiners can make are either to order re-examination, refuse re-examination, or as we see on occasion, there's something wrong with a request and an opportunity is provided to correct the oversight. When that is done, there's a new filing date that's assigned to the re-examination request. There's not much criticality to filing dates, unlike regular applications. In re-examination requests, filing dates are not that critical, so that's not a big problem. From experience, I can tell you that most of the time when examiners issue one of these actions that give the requester an opportunity to correct, quite often it's done just as a tactic because the examiner is overworked, is not able to make a proper decision, and yet he or she have no option of waiting more than 3 months. By statute, they must make the decision within 3 months. So one of the ways to handle it is find some imperfection in the request, say, you didn't do this, that, or the other thing. I'll give you an opportunity to correct. Once you correct it, that gives you a new filing date. Now the examiner has 3 months all over again in which to make a decision. So just a tactic quite often to buy time. If reexamination is ordered, which is what happens in an overwhelming majority of cases, as you'll see later on in my presentation, the patent owner has 2 months within which to challenge the examiner on his decision by pointing out why reexamination should not have been requested or why the third-party requester is wrong in the suggested rejections. While this can be done, our firm is pretty typical of most practitioners in the reexamination area, which is to discourage that practice. In other words, we generally don't like to file these statements by the patent owner if it's the patent owner we work for. And the reason is, in an ex parte proceeding, as I said earlier, once the reexamination is granted, that's it. The third-party requester is out of the picture, except if the patent owner does file a statement, that permits the third-party requester to get back in the picture, make further arguments. And if you represent the patent owner, you never want to give the other side an opportunity to get into the examiner's ear. Once reexamination is granted, the PTO generally takes 9 to 12 months. This, of course, varies depending on each examiner's workload, in which to make a decision on patentability. And just so you understand the process, the fact that the examiner finds that there's a substantial new question of patentability that has been raised by the third-party requester does not mean that within 6 to 9 months later, the same examiner will not say patentability of all claims is confirmed. So just because there's a new question, it does not mean that the answer to that question is going to be negative to the patent owner. It could still be a favorable outcome. In ex parte proceedings, interviews are permitted, and we very strongly recommend it to our clients. You can be much more effective in arguing your case personally before the examiner than when you do it in a lengthy written submission. One of the prohibitions in reexamination proceedings is you cannot broaden the scope of the claims. You can change the claims, you can add claims, you can certainly subtract claims, but you cannot broaden. Also, the only documents or the only challenges you can make to the validity of patents under the reexamination proceedings is you have to use a prior art, such as a patent or a printed publication. Even if you have the strongest evidence that something was on sale for more than 1 year in our system, it's okay to have something on sale for up to 1 year and still get it patented. Even if somebody has evidence that you offered it for sale for more than a year, or they have the strongest evidence that the claim is indefinite, no matter what other legitimate challenges they come up with, it cannot form as a basis for a reexamination request. Our lawmakers have limited the scope of these types of challenges. They did not want to reopen the door on every possible challenge in the current system. I will not discuss some of these technical details in my slide presentation because of the limited time I have. One of the things that we run into, I handle patent prosecution, for instance. There are a number of patent attorneys out there who handle litigation. And so in parallel, quite often, I will be handling the reexamination request before the patent office, while at the same time another attorney may be challenging or bringing legal action in court relative to validity of a patent. And quite often courts will stay the court proceedings to permit the patent office to make a decision, but not all the time. Sometimes both the court and the agency conduct review of an issued patent at the same time. Whether the proceedings have been stayed or not, there is a little bit of tension between litigating attorneys and prosecution attorneys in how we handle things. And what introduces that tension is litigators want us to say as little as possible on the record. Once we make an argument, and during prosecution, they are stuck with that argument. There's a file wrapper estoppel against them basically taking an opposite position to the one we took in prosecution. And so because of that, they like for us to say as little as possible. On the other hand, the dilemma we have is if we don't say enough, we're not going to be able to change the examiner's mind, and so the litigation attorney will not have a patent to defend because we won't be able to get the patent confirmed. The other source of diverse interest, perhaps, between the prosecuting attorney and the litigating attorney is, in order to get a claim allowed during regular prosecution, what a patent practitioner would do is make whatever changes are needed to get that claim allowed. Well, if you make changes in reexamination, that restarts the clock when it comes to damages. So when the litigation attorney sues an accused infringer for infringement, any infringement that took place prior to the reexamination certificate being issued can only result in monetary damages if there are original claims that are confirmed. If the only claims that are confirmed as being patentable are claims that have been amended, they're new claims, then that generally results in no past damages and only future damages for infringement. Because of that, firms like ours, so I'm sure we're not the only ones, we are very reluctant to amend claims during reexamination. We will only amend them if we absolutely positively have to. And even then, generally because of some indefiniteness that got into the claims during original prosecution, and we have no choice but to fix those. Other than that, if we want to further limit a claim, a good strategy usually is to introduce that new limitation in a dependent claim. Or if we choose to draft an independent claim, we will make sure that there are just very slight, perhaps, changes in terminology from the original claim, and then introduce perhaps some additional limitation, while the entire time being very careful with not broadening the scope of the claims because the examiner will not permit that. Just so you understand the mechanics of reexamination, typically if the examiner rejects a claim during reexamination, that's generally a non-final rejection. The patent owner's representative has the opportunity to amend claims, make arguments, go in for a personal interview. If it's an ex parte reexamination request, interviews again are not permitted in inter partes requests. And then what usually follows after that is either an examiner being persuaded with regard to at least some of the claims and continue to reject the others, or perhaps if we're really successful, the examiner will confirm patentability of all the claims, perhaps even some new ones. And incidentally, it's not unusual for a firm like ours to start out with a patent that had 21 original claims that we're trying to defend, and by amendment introduced another 80 claims. So now the examiner has 100 claims to examine instead of 20. It's not all that infrequent that that happens. So we might get some of the claims confirmed, but not all. In some cases, get all of them confirmed. And quite often the requesters wish they had not requested reexamination, because now, in fact, we have a stronger patent that the litigators can defend in court. If the examiner rejects at least some of the claims, quite often, not in all cases, but quite often, the examiner will issue a final rejection. From a strategic standpoint, it's good to bring in an expert's affidavit in order to strengthen the arguments that you are making. Eventually, what you hope is that the examiner will confirm patentability of all the claims by issuing a NERC, which stands for Notice of Intent to Issue a Reexamination Certificate. I'll skip over some of these slides. I have some very interesting statistical data that I'd like to share with you. I'll make the slide available to you, the PowerPoint presentation that is. So I'm not going to cover all these statistics, just the more interesting ones. And that is that roughly 92% of all ex parte reexamination requests have been granted, and 95% of inter partes requests have been granted. The average pendency for ex parte reexamination is a little over 2 years, a little over 3 years for inter partes reexaminations. And here's some interesting statistical data. In ex parte reexamination, all claims have been confirmed in 23% of the cases, and only ex parte proceedings, only 11% in inter partes proceedings. The certificates with all claims canceled, so basically the patent's no longer valid, that happened only in 11% of the ex parte reexamination requests, but in 44% of the inter partes requests. And situations where some claim changes were made, that happened in about 2/3 of the ex parte proceedings and a little less than half of the inter partes. Only about 1/3 of ex parte cases are in litigation, and about 70% in inter partes. That concludes my presentation. I will leave the website on for just a minute here. If you would like to write it down, if you go to our website, this entire PowerPoint presentation can be found on our website, and you can make use of it. Thank you.